welcome Shawn Tuma.
Thank you.
Good afternoon. First of all, yes, my name is Shawn Tuma. I have been practicing in the area of cybersecurity law since before Y2K. And because of that, I'm going to thank those of you that are here this afternoon, but I'm going to ask you, if you decide to take a nap, please don't snore, okay? And I'm going to tell you why in a second. But seriously, thank you for being here, because I know having me be the third lawyer on the agenda, it makes it pretty tough to want to stick around and listen. But there's differences in what we do. You know, Candy was up here and she did a fabulous job of talking about the role of a prosecutor in going after the people who cause these sort of crimes, who cause these sort of breaches. And then Sarah was on the panel last and did a great job of talking about her practice, which I think is probably a lot like mine. We're in the civil arena, and we primarily represent companies in civil issues. So I just want you to understand the distinction between what we're looking at here. And I'm going to get into that a little bit more in a few minutes. But the reason I want to thank you and ask you not to snore is because on April 1st of 2000, I did my very first presentation on what was becoming cybersecurity law, where I had the role of talking about Y2K litigation, which did not exist. I had to stand up and talk for an hour about something that didn't exist. And that has been a great segue into this area, because what I've heard over the years is, you know, Shawn, don't come in here wasting our time talking about data breach. Don't talk about cybersecurity. You know, and this was a few years ago, because we've heard this out of you before. But let me assure you, this is not Y2K. We're not dealing with the Y2K issue. This is a very real issue. So the first question I want to ask is, how many of you in here have been involved in a data breach in an organization? Doesn't have to be the one you're at now. Okay, for those of you who have, you understand why I have the image of a burning building on the back of this screen. Because it's chaos. It is panic. It's people running around scared, not knowing what to do, and really just trying to find some hope in the situation. And saying that, I speak at quite a few cybersecurity conferences, and I'm incredibly proud to be a part of this conference today. And I commend everybody who put this conference on and the speakers, because what you usually hear at cybersecurity conferences is a whole bunch of scare and nothing else. But what we've heard here today have been very practical solutions, very practical advice on how you can help make your company be more secure, not necessarily secure, but more secure. And there's been one overriding theme that I've heard throughout the day, and it's really stuck with me, and it reminds me of a saying that I've heard a few years ago, and I kind of adapted it to cybersecurity. So I want you to think about this. This is our philosophical moment. You do not drown from falling into the water. You drown from failing to get out. Think about that. What have you heard here today? Being attacked doesn't bring your company down. Being breached doesn't have to bring your company down, doesn't have to be catastrophic. Okay? Having a significant breach, if your crown jewels of your company are protected, doesn't have to be catastrophic. So the key is learn how to swim, figure out the solutions on how a breach event for your company doesn't have to be catastrophic. And what I'm going to talk about today are the legal issues. Now, I know what you're thinking. Legal issues in cybersecurity, right? It's more of an IT problem. But what I want to help you understand is that it is a legal issue. So the next question I'm going to ask you is, why do you think you know of all these companies having data breaches? Anybody? You think it's because they're nice and kind and good and they just want to share that information with the world? Absolutely not. It's because the legal obligations force them to disclose what happened. prescribes how they must respond, how quickly they must respond, what they must do, what types of notifications they must give. The legal obligations control all of this. So now my next question, how many of you in here were involved in either the Ashley Madison or the Brazzers data breach? Anyone? Okay, good, y'all are awake. All right, thank you. But yes, cybersecurity is clearly an IT issue. It's clearly a business and PR issue, but it is definitely a legal issue. And the way I like to refer to it is this. IT and security protect your company's data. Legal protects your company from your data. Cybersecurity is one of the only areas of law or policy that I am familiar with where the victim company, the company that is attacked, the company that is the victim of what Candy has to go prosecute, becomes the bad guy. Think about it. Think about the public discussion of a company after a data breach. They are now the bad guy because they allowed themselves to get breached. I don't know of any other area of law or policy where that's the case. And so we have to do things to help protect the company legally from the ramifications of being a victim who was compromised. Now, in my role, usually when I get a call about a data breach, it is someone who's in a panic. And my first role is to be a counselor. Now, all of you in this room may find yourself in that situation where you receive that first call from someone saying, oh my God, this is real. Yes, it really happened. You know, okay, the Candy and the Secret Service came in to talk to you and told you you had a breach. You said, no, we don't. And then the IT guy went and sucked along and found it and called the CEO and said, holy crap, yes, we do. What do we do? If you're in that position, your first role is to be a counselor, psychologically speaking, to bring peace, to help calm people down. You know why? Because nobody makes good decisions when they're in a panic. Nobody makes smart moves when they're running around with their hair on fire. So what do we all know about life whenever we have uncertainties coming up? Plan for it. One of the things I'm going to talk to you about in a little bit is a breach response plan. Plan now for that event. You may not know everything that's going to happen, but you'll know a lot more if you prepare ahead of time and at least have a framework to work from. So, why the panic? Because you have all of these legal obligations. Now, recently, I talked to a law professor about doing a project together, and I was really excited about it, and I said, Professor, let's, take this issue of cybersecurity law and expound upon it. And he said, well, before we do that, we have to determine, is there a law of cybersecurity? I said, never mind, done, because I see all this daily. I get news feeds daily. I get updates daily of laws that come out, of rules and regulations that come out. Yes, there is a law of cybersecurity, and these are the obligations that you have to go through. One that's most important, and you can't see that, is contracts. Contracts are becoming a huge part of the law of cybersecurity. Most companies don't even realize it. They don't realize that the companies they're signing on to the contracts are creating legal obligations that they must later comply with. This all sounds horrible, right? I'm back to the fear and the doom and gloom. I apologize. But there is hope. And this hit me a few years ago when I too was one of the ones out spending all my time talking about the fear part. And I realized, I read this report by the Online Trust Alliance. And it said, very few of the data breaches that actually happen are these super sophisticated North Korea taking down Sony type events. Most of the data breaches are simple things. They're failures of the basics. That creates hope, right? Because what we don't want to do as cybersecurity professionals is create a sense of hopelessness amongst the people that we need to be taking action. Because when it's hopeless, what's the point? And that's what I hear a lot from business, from board members, CEOs, is what's the point? And the point is there is hope, because each year the Online Trust Alliance does this report and finds that roughly 90% of the breaches that happen each year are failures of basics, simple things that can usually be solved within a company. The Verizon Data Breach Investigations Report, fabulous document. I got to tell you, I loved the presentation at lunch. It was spot on, and it just was great. And I actually did this slide before that presentation, but the reason I did is because this is another source I looked to. It confirmed that 60% of the breaches, 63%, resulted from weak default or stolen passwords. It's a password issue. It's not North Korea or another state actor taking down your company. Data is lost over 100 times more than it is stolen. Now, I guide companies through data breaches, and I do quite a few each year. Most of my experience is 100% consistent with this. It's not sophisticated hacking. It's some knucklehead that lost the thumb drive that had the patient data on it. It's somebody that, the general counsel that put their unencrypted hard drive in their computer in the back of their car in their briefcase and went out for happy hour, and it got stolen. That's the kind of stuff we generally see. It's the spear phishing. It's the business email compromise. I've had more of those this summer than I know what to do with. Of the HR professional emailing out the payroll information and the W-2s for all the workforce. Folks, this is stuff that can be fixed. This is not super complicated. You may not make yourself 100% secure, but you can become more secure. And if you can become more secure, you've got hope, and there's things you can do. Now, it's football season. I took out my Sun Tzu slide, and I put in the great Vince Lombardi, because I've always found inspiration in this. Focus on the simple things first. I'm not saying don't focus on the other things too, but cover your basics. Train your workforce. Teach your employees how to understand and recognize what a phishing email looks like and the telltale signs, and that it's from a person of authority and it's a high urgency and they're asking for something. Teach them this stuff and you will go a long ways. Now, I have another little saying. An ounce of prevention is cheaper than the first day of litigation. Look, litigation is what keeps me in business. I'm acting against my own self-interest here, but it's the truth, okay? How hard is it to put a policy in place within your company governing and restricting how your workforce can use your computer network? It's not that hard. It's cheaper than the first day of getting ready to go down to the courthouse. How hard is it to train your people? It's not that hard. So, what do the lawsuits say, right? Everybody's in fear of the lawsuits right now. Consumer class action lawsuits. That's the big threat against companies. The truth is, right now, consumer class action litigation against companies from a data breach isn't that big of a deal. It's expensive because you've got to pay your attorneys to defend it. You've got to go through the hassle of it. But the plaintiffs aren't scoring direct hits. It's like a game of Battleship. Right now, they're kind of hitting around the edges, but they haven't had any major direct hits in the consumer class action lawsuits. Why? Because they cannot show harm. They cannot show they were hurt by Target's data breach and not by Home Depot's data breach, if they were even hurt at all, or not by Dairy Queen's, or Michael's, or Neiman's, or whoever else's. So that's not the big threat. But what we have learned, this is a takeaway for you, is the standard of care is reasonableness, not strict liability. Just because you have a breach event and data gets compromised does not mean you are automatically going to get your company's head chopped off. The question is, were you reasonable in protecting the data? And can you document it and can you show it? And the other lesson, and these both came out of the Target litigation, is if you have it, use it. Okay, in the Target case, the judge never made a full finding. It was just preliminary motions, but this is kind of all we have. The judge said, you had sophisticated equipment in place and you turned it off. Okay, that's indicative of negligence. If you have it, use it. So then I got asked by some people, well, does that mean we shouldn't have it? No, I'm not saying that. I'm saying have it and use it. So that's one takeaway. The other takeaway, look, class action lawyers are not your big concern right now. Your biggest concern is the FTC. The FTC wants to control this whole area of regulation. They want to be the big boss when it comes to cybersecurity. And they're being very aggressive in exerting this authority. And they went after Wyndham a few years ago. Wyndham had 3 breaches. When you look at the case, it was, clearly negligence. I mean, they had done things that most would agree were improper. And so the takeaway from that, and I really don't have time to go through the cases, but the takeaway from that is the FTC said, this was in 2013, I believe, and you did not even have the rudimentary basic IT practices that we publicized back in 2007. So you've got to have basic IT security. That's another takeaway. Another case, FTC versus LabMD. LabMD got smacked around because they had one employee who had downloaded and installed LimeWire on the company's computer that it shared a file that had PHI information in it. The FTC found that you have to have internal network controls to control how employees have access to this kind of information. There's a lot more to this case. I just don't have time to go through it, but the takeaway is you need to have some kind of controls on sensitive data within your organization. This is consistent with what we've heard all day. Another case, the SEC went after a company called RT Jones, and this one's really important. I think this one's probably your first step. They found that RT Jones did not even have basic policies and procedures within their company to protect sensitive investor data. Now, what I'm talking about here are things like a computer use policy or a section of your employee handbook that would say, this is sensitive information. Don't do this, don't do that. Whatever is appropriate for your organization. But look, it's not terribly expensive or time-consuming to do those kind of things. There's no excuse to not do it or for not doing it. Your procedures. Think about the data in your company and how you need to protect it. Okay, the SEC reaffirmed this, and they said failure to do so violates the safeguard rule under the Securities Act. Now, another takeaway from this case is that the SEC said you must have a basic written incident response plan in place. This is part of that diligence. Remember, you don't drown from falling in the water. You drown from not knowing how to respond. Start now. Put a basic incident response plan in place. Okay? If you take the information that Candy had on her slide, which is great, and it's focused on law enforcement. And then here, I just tweeted this out about 2:15, by the way. If you want to download a copy of this checklist, it's just a checklist, not a response plan. But download it and look at the things that I usually have to do for a company when we go through a breach response. It'll give you an indication as to why you need to start preparing now, and it'll show you the things you need to look at. So you must have a written incident response plan in place. This one's really important. FTC in late 2014 said, and this was in GMR transcription case, you must investigate, obligate, and verify the security practices of third parties that you do business with. Anybody want to guess why? The Target Fazio scenario, right? What was mentioned at lunch. That Fazio was used to get the login credentials to get into the Target network. That's the FTC was responding to that and said, we recognize what Sun Tzu taught long, long ago. If you can't hack from the front, use indirect means. Adapt to the environment. All right, this is what the hackers do. Okay, they recognize that hackers tend to use third-party business associates to try to get to their primary objective. Now, you see the little NIST symbol up there. Let me tell you why I put that up there, because I hear a lot of people questioning the validity of NIST versus ISO versus blah, blah, blah. What we've seen are the primary regulators in this environment are federal government, it's the FTC and the SEC, and other government branches. They tend to look to the NIST standards for acceptability. So if you're asking yourself what's the validity of NIST, a lot of these opinions reference back to NIST. So take a look at NIST and have that in your toolbox. Contractual obligations. This one, I mentioned it briefly earlier. You've got to know your contractual obligations. This, how many of you have seen a master services agreement that has a privacy or data security addendum attached to it? A lot of you. If you haven't, you will. You will see more and more and more. This is a product of the recognition that you must verify, obligate, and whatever the other one was on there about your third-party business associates. These are the contracts that do that. They focus on the data, like Jeff Schilling said earlier. They focus on the data. These focus on the data. You're obtaining information from some other business, data that they're obligated to protect and keep secure. So they're sending you a contract that says these are your agreements and obligations on how you're going to do that. Far too many business people get these. The COO never bothers to consult with IT about it, never bothers to ask anyone else in the organization, signs off on these things and agrees to all kinds of limitations and obligations that they would not otherwise have agreed to. Pay attention to these, because what we're seeing more and more is data security law, cybersecurity law is becoming the law of contracts in a lot of ways through breaches of these agreements. So focus on that. Now, another issue that came up this morning, came up quite a bit today, that's the role of officers and directors. As John South mentioned, we need something to push officers, boards of directors into acting and into taking this issue seriously. I see it all the time when the CISO calls me and says, I can't get anybody to move. We've got to do something. Now, the plaintiff's attorneys are doing something in this regard. They are pursuing shareholder derivative cases against companies that have data breaches. They're not having a lot of success in the consumer class action litigation. So they're shifting their tactics and they're using shareholder derivative as a way to try to get money, because that's what we attorneys do. We try to get money. Not all of us. But they haven't had a lot of success, but the threat is very real, because what they're doing this under is what's called the Caremark standard. And under the Caremark standard, the company is not allowed to pay for the director if they can show the directors utterly failed to implement a reporting system or controls, or consciously failed to monitor and oversee what they were supposed to be doing. Now, this means the Maserati in the vacation house, right? This is not just saying, oh, well, another obligation of the company that's going to have to be paid. This is hitting them personally. No case has made it there yet. It's still this game of battleship, but they're getting closer and closer, and it's really just a matter of waiting for the right case. The one that made it the furthest was a derivative of the Wyndham case called Palcon versus Holmes. And in that case, as egregious as Wyndham's IT was, their security, the court found that on 14 different occasions, the minutes of board meetings reflected that there were discussions of cybersecurity and that certain things were implemented, and they said it may have been horrible, but it fell within the business judgment rule. So the lesson there is document, document, document. The regulators are looking for negligence. When you can show that you've tried to be reasonable and tried to do the right thing, you're going to pull yourself out of that. I've yet to have a case where I've been able to provide to one of the state's AGs who followed up and said, you know, what did the company do? And I have a nice file of information to send over and show everything they did. And they, every time, it goes away because that's not the people they're looking for. Cyber insurance, I don't have time to go through it. You need to at least look into it. You need to at least consider it, and if you don't get it, you need to write down and document why you didn't do it. So what does this ultimately mean? How do we bring peace to your organization? Here's how. Of the general process that I've seen over the years, what seems to work the best is when you have an assessment of what your risk is. Whenever you strategically plan around that, and by the way, you can document each one of these steps, you then deploy whatever assets you need, and obviously these are going to be your service providers, your vendors, whatnot. You develop and implement policies and procedures and a breach response plan. Have it all written, have it all prepared. Then you do tabletop testing of what you've now done. Test it, see how it works. And it's not going to work great, so you're going to learn from it. So you're then going to reassess and refine. Sorry for the small font. I can't read it either. Reassess and refine, and then you start all over from the beginning. And if you'll do this and you document each one of these steps, not only will your company ultimately be more secure, you're going to be in a much more legally defensible position, and that means a lot. So with that, I'm done. Thank you all very much.